Hey out there, legal warriors. In this video, I'm going to cover a very important question for many people in Washington state. Do you have to pay a civil demand from a store if you or someone you love is accused of shoplifting? If you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. What is a civil demand? What are you even talking about, Lance? Well, if you know anybody who has been accused of a theft charge in Washington state, it's usually at a store. Nordstrom, Macy's, could be Target, Costco, you name it. And typically what happens is someone at the store stops someone for not paying for something. Maybe they didn't pay for it on purpose. Maybe it was an accident. But the police are going to get called and someone's going to have to go to court for theft. And most people think about, how do I defend the theft charge? Well, as part of that, usually what will happen is the store personnel is going to say something like, hey, you're going to get a demand in the mail from either us or our attorneys for money, a civil demand for payment of money. And a week later, 2 weeks later, a month later, the person who's accused of doing the stealing will get something asking for some money from some law firm, usually on behalf of the store where the alleged theft happened. Sometimes they do it right at the store, but usually it's going to come in the mail. And what that is there's a law in Washington, and the law is RCW 4.24.230. And I had to look it up for this because I've always sort of known it in my head from doing this for 30 years. But basically, the law says if someone that's an adult is accused of shoplifting, the shopkeeper can sue you civilly outside of the criminal process for money damages. And it says in the statute, the most current version, it changes apparently all the time. In 2024, it says that the shopkeeper can ask and sue you for the value of the merchandise up to $2,450 worth of merchandise, the value of the merchandise, plus an additional fee of between $100 and $650, plus any attorney's fees or court costs. If it's a minor who has allegedly taken the goods, the parents can be sued for half of that total amount, basically it's the full dollar amount of the property taken up to $1,425, plus another $100 to $650. So what that means is you're going to get a demand for money that is a higher cost than the cost of the goods that were not paid for. Even if they recover the goods, they can still ask for this money. It doesn't matter if they recover the goods or not, or the services. And think about it, it's a way for the shopkeepers to recover their enforcement costs. And so you get this letter in the mail, and it's separate and apart from anything that happens in the criminal court. And we get asked all the time, should I pay it? And the answer typically is, for us, we say, yes, you should pay it, but only through your attorney's office. If you don't pay the civil demand, then that store may choose to sue you for their civil cause of action. And if they sue you, guess what's going to happen? The costs are going to go up. There's going to be attorney's fees tacked on. The statute is very clear that the person that is being sued, if they lose the lawsuit and they can show, the store or the store's attorney can show that you did something wrong or your kid did something wrong, if it's a minor, then you're going to lose and have to pay. But why would a defense attorney say you should go ahead and pay that? Well, if you've seen other videos on my channel, one great way to get rid of a theft in the third degree charge, to get it dismissed, is through a statute called compromise of a misdemeanor. RCW 10.22.010 says that if a victim of a crime states they've been civilly satisfied for their damages and they appear in court, and we say that means in writing, then upon motion of the defense attorney, the court in its discretion can dismiss the case, which means the case is dismissed. So it's a great tool. We want that civil demand to show up. And in my law firm, if the civil demand isn't showing up, we might give them a call and say, hey, where's the civil demand? because if this is a first-time offense or even sometimes a second-time offense, we may be able to get the store to sign a statement of civil satisfaction that then us lawyers can use to ask the court to dismiss the case. Now, what's the gotcha in there? What do we have to worry about, right? Well, the statute says that right on the paperwork, it needs to say, paying this does not relieve you of criminal liability. And the reason why that's there is so it doesn't confuse people. Hey, I paid the store, so I'm not going to be prosecuted now. No, that's not correct. But the gotcha is sometimes an uneducated prosecutor, and there's plenty of them out there, looks at that release. If it says that, this doesn't release you from criminal liability, and they'll make a claim that therefore then you can't use that to compromise a misdemeanor. And that, I believe, and I think most courts believe, is not an accurate reading of the law. If we look at the law, it does not require the prosecutor to agree to dismiss the case. It doesn't require the store owner to agree to dismiss the case. In fact, that's why the discretion is left with the court. So the reason why that statement would be in release paperwork is because it's required to be on the original piece of paper that you get sent asking for the money, and therefore they often put it on release paperwork as well. If your attorney has a chance to draft their own release that makes it less confusing, that's always a good idea. So what you do want to do is you generally want to make that payment. And again, you're going to want to talk to your attorney. But why do I say you want to pay it through your attorney's office? Because again, just paying it isn't enough. There needs to be some type of statement that your attorney can show to the court. And I don't mean your canceled check. So if you just pay them the money, you don't have a civil release for them to sign. You probably haven't put a self-addressed stamp envelope. You haven't talked to them and say, are you going to sign this and send it back? You want to go through your attorney's office because they process hundreds and maybe thousands of these companies that represent these major corporations, right? And they're not going to put in a lot of effort. So if they get something to sign and send back at the same time they get a check, they're more likely to sign it and send it back, because that's what we need. That's what we need to ask to try to get your case dismissed. So should you pay a civil demand? Probably. It's up to you. If you don't, will they sue you? They might. It depends how much they're asking for. And remember, they can ask for the cost of the goods or the services plus a number of $100 to $650. So if you alleged to have stolen $200, they could ask for $200 plus $100, which is $300, all the way up to $200 plus $650, which is $850. They could tack on a few other costs, but usually it's in that range. When I reread this statute, because not many attorneys, read statutes again and again, we sort of just know how it works. This statute also applies to if you eat part of a meal and don't pay for your meal, or if you don't pay for your hotel room. It also specifically applies to those situations. So hopefully you get that civil demand in the mail if you're in this unfortunate situation. Hopefully you can take care of it through your attorney. Hopefully they can get the right type of release, and hopefully that's one way someone can get your case dismissed in Washington State. So if you found this video useful, please like and please subscribe. More people will get to see it. More importantly, if you have a legal problem in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.